the today's topic, which is assigned to me, that's a comparison between the objection and the opposition in the trademark law. So I'm sure that most of you, those who have attended this session, are well aware about the intellectual property related laws, means trademarks, patents, copyright, and design. But mainly, I'm focusing today on the prosecution part of the trademark. Prosecution part of the trademark means how we procure the right of the trademark from the tribunal, that's a trademark registry, and how we get it, and the various terminology which are generally used during the practice of the trademark prosecution. So before that, I give the glimpse about my detail of the lecture. The session will follow with the understanding of the Trademark Act, understanding about the objections which are raised by the registrars or oppositions which are raised by the different parties, their consequences, the uses, and the effect in the practices. So let's start the topic mainly. As you all are aware about the trademark law, which is generally given to procure the right of any brand name or the name which you use for your goods or for the services. Whenever we do any business or whenever we use any product or services, there's a name given to a particular product or the services. Either you go on general store and ask for Head and Shoulder or Lux or Dove, that's the name of the brand, and it's legally protected, is considered the trademark protection. Or for services like any education institute name or the insurance company's name or the law firm's name is also considered as a service mark. But generally, the widely trade TM word is denoted for trademark is used to represent any product or services. So whenever you think either you are established businessman or you have just started your business and you are launching your product or services in the market, so you put a name into it, and that name is considered or create with the time the goodwill in the market. So to stop others or refrain others to your name or make your own identity to procure your own right, there's a government organization that's called a trademark registry, which gives you the legal right for that particular name, so that you own that name and you claim in the market that this is owned by me, nobody will copy or nobody will use without my permission. Now, in the practice of procuring the name, there are a lot of incidences wherein people, either the applicant, the owner of that brand, or the practitioners, those who are the beginners in the field or are a little bit less aware about the law, like doing the other legal practices also, generally get confused with the two terminologies, which is the main topic of today's topic, the objection word and the opposition word. The objection is generally considered or overlapped with the opposition, which is raised entirely different by one. Objection is and part of the prosecution wherein the trademark registrar or the examiner will object or to your application of the trademark, while the opposition will be opposed by the third part. He could be anyone. So the first introduction of the trademark, as I said, that any name, brand name is capable of distinguish and identify of it could be an alphabet, it could be a digit, it could be a logo, it could be a design, it could be a font, it could be anything. And it should be different from the goods of services from one person to other. The packaging and the other outlook of trade dress can also be included into it. The prosecution process, when you own a brand name, you go and apply before the trademark registry. In India, there are division of the jurisdictional right of the trademark registry. There are total 5 registries, wherein the north part of India is divided in or the assigned to the Delhi Design Registry, while the eastern part is given to the Kolkata Trademark Registry. The southern part is given to the Chennai Trademark Registry, and the western part, there are 2 parts. One is in Mumbai, that's Mumbai Trademark Registry, and Ahmedabad Trademark. The total number 1 additional registry is there, which is in Ahmedabad. So first you make and inform one simple application to the trademark registration. That's called trademark registration process. That's called a prosecution process, which has a 9 different steps. First, when you make your application in a specific format with the specific fees before the jurisdiction wherein you are residing or doing the business. Like In Mumbai, if you're residing, so you prepare your application, you submit to the Mumbai Trademark Registry. And when you submit that trademark registry, the trademark registry has its own process that's called prosecution process of taking the application, raising the questions of your applications. Could be that you have not submitted your trademark registration as per the prescriptions or the specification provided under the Trademark Act. But you have submitted whatever defined under the Act. After the submission of our applications, the application will be kept under the examination by the examiner. Examiner will look from the different aspects of the Trademark Act that whether your application has been filed as per the sections or the rules of the Trademark Act or not. So the main sections which are invoked in the filing of the trademark prosecution process are Section 9, which is absolute ground for refusal of the trademark. Second section is Section 11. That's relative grounds for refusal of the trademark. And there is one more section, that's 18, that's the inherent power in the trademark registrar to give you right or not. Mainly, if we talk about the Section 9, Section 9 talks about that the trademark should not be having a divide of distinctive character, or trademark should not be generic. That's a commonly available trademark or the generic name, you should not file it. Those marks which are hurting the religious sentiments are also not allowed. Those trademarks or the names which are having obscene content or the material are also not allowed. Or those trademarks which are showing the national emblems are also not allowed. Those trademarks which are using the geographical locations name or any particular celebrities names or which is connecting to a specific identity is also not allowed into the Section 9. The shape of the trademark, which is having technical features, are also not allowed. Shape of the trademark is allowed, but if it is showing the technical feature of the trademark, that is also not allowed. Section 9 is considered the stringent section wherein it is primarily considered that whatever the trademark you have filed should not contain all those limitations defined under the Section 9. So if your trademark is containing any of that, that's why it is called that whenever you file a new trademark application, it should be coined word. It should be very different. It should not be generic. It should not show the kind, quality, value of the word. Kind, quality, value of the work means if we file like Apple, so we cannot file a best quality word for it. Or if you are filing for ghee, so you cannot write a should or pure or number one, or so those things are not allowed under Section 9, which people say that these names are giving leverage to sell their product. But under Section 9, those things are not allowed. So the objections, the first thing which is raised by the registrar or the examiner is absolute grounds for refusal. So they are, or they would not allow any trademark which is containing these description under the trademark which you file for it. The another section which is a little bit which is not used widely under the trademark prosecution, but yes, that has a specific meaning also. That's a limitation of color. Limitation of color are used generally nowadays, has become more usable in the commercialization of their product. So for an example, if you are only limiting your brand to a limited colors or a specific degree of color, like Colgate has a combination of red and white combination, wherein if you do not see the name of the product and if it is kept in the shelf of any general store and you just see the color of that box and you say that, okay, yeah, I need that one, that product, even though you do not or you cannot pronounce that word Colgate, you have a specific identity of that brand that's in red and white combination, the Colgate. So they have limited their identity of their color under Section 10. So the trademark registrar can limit that you are only limited to those colors. Similarly to the Maggie, specifically the yellow and white combination. Tide is orange and black combination. There are a lot more products which are there in the market which are only limiting to their specific color or the limit. So this is a second objection which is raised by the trademark registrar That's a section 10. That's a limitation to color. Then section 11. So we just learned about in section 9 the absolute ground, which was very stringent. Similar to that, the section 11, which talks about the relative ground for refusal of the trademark. So in section 11, so those grounds are not subjective to the nature of the product, or which is taking the advantage of any identity of the product in the market. But if the similar or the same or the identical trademark is already filed before your trademark, then section 11 will apply, and the registrar can refuse your trademark application by giving the example of that since the others similar identical names are already filed by someone else and they got the registration, you cannot have the same kind of registration. The reason behind it, the preamble of the Trademark Act says that your trademark should not confuse thus that to the consumer that this product is made by the prior applicant or the prior user of the trademark. This means people should not get confused by thinking that subsequent trademark is related to the already available or the famous trademark in the market. So mainly section 11 talks about the any trademark which is already on record at the trademark register or which has been filed but has not got registration so far. So at time of filing of the trademark application, when you check that how many similar trademarks are already there on record, those might be registered or not. But it is advisable if you find any trademark which is already existing before you file, then you should not, or you avoid that trademark to be filed before the trademark registry. Section 11 has in different other sections also, like comparison with the different well-known brands. Now, the well-knownness could be established through the availability of the brand in the market, reachability to the customers, or how many people are aware about that brand name in the market, the longevity of that brand name in the market, or the popularity of that brand name, the turnover of that brand name, or advertisement expenditure on that brand name, multi-country availability of that brand name. So there are a lot of factors on which well-knownness could be defined. So the section 11.6 specifically talks about if any brand name is a well-known, or more specifically, if a prior brand name is already well-known, the subsequent trademark cannot gain registration in other classes also. Sorry, I could not explain you. In the trademark registration, there are a lot of sections or classes are there. Classes of goods and classes of the services. So there are 1 to 45 total number of classifications are there. And those, as we follow nice classification, so according to that, 1 to 34s are for the goods. Like class 1 is for chemicals, class 2 is for paints, class 3 for the cosmetic products, class 4 for oils and related product, 5 for pharmaceuticals, 6 for irons and other product. So similarly, class 1 to 35, there are different products categorized under the different classes, and from 35 to 45 for the different services, for advertisement, for 35, for 36 real estate, 37 construction, 45 for legal services. So 1 to 45 different classes are defined. As I was explaining the well-known brand, so if your brand or any brand is already well-known, so there is a limitation under the Trademark Act that even you file under a different class, which is not being done by or not filed by already available trademark in the different class, and which is well known. Well known means, suppose for an example, Adani is means the Adani brand name is filed for oil and gases under class 4, and they are not doing any business under class maybe 32 as for pan masala, and neither they wanted to do with this business in future. So even though on having that apprehension of that they would not file it, that application, that they are not intent to do the business in this category, we can file the same Adani name in that class 32 and can procure it. the trademark registry will not allow you under section 11.6, since that brand name has become well known and that's already very famous in the market. Even though they are not doing business in that particular class, but you cannot file that trademark application and cannot have that name. So mainly there are two sections, section 9 and section 11. Section 9 is for absolute ground and section 11 for relative grounds for refusal of the trademark. But apart from that, there are a lot more other trademark sections which are generally used by the trademark examiner or the registrar to not to give you the right. Section 12. Section 12 is honest and concurrent use, wherein you think that there's a term called user date, who is prior in the market. Sometime it happens that for an example, for an instance, suppose I stay in a village and I've been doing the business since last 20 years, but I'm not aware about that there is a law, a trademark law is there and I should protect my brand name. However, I'm doing my business. I've been doing it since last 20 years, but I was not aware about the trademark law and did not file it so far. Someone else subsequent to me is well aware about this and he has filed the trademark application, got the registration also. When I got to know about this, okay, this guy has filed, which is in same business of mine. And now there are chances, since everything has gone online, now there are more chances that our brand name could get conflicted in the market and the people can get confused if we use or when we reach to the different places or different geographical places. Now, that's the main matter of the consideration is the user date. Who is the prior user? Prior user means I started my business 20 years back, but I did not file the trademark application. That does not mean that they take away my right, even though I have not filed my trademark application. So at the time of the filing of the trademark application of the other party, registrar will also consider that, however, these names are not there, but we could consider that these things should not be in the mid of our prosecution process. Prosecution process will always look that whether the name is available on record or not, but they will also consider that these kinds of names are famous or not, even though those trademarks are not filed. So under section 12, when subsequent trademark will claim his right before the trademark registry, they may claim that they are the honest, they have taken that name honestly, or they are the concurrent user of the trademark. So registrar with in their consideration of that the facts or the evidence is that the subsequent applicant is the genuine user of that similar or identical trademark of the prior one, or they would say that they have recently or concurrently started. It means it could be like if someone has started using 2022 and the other guy has just started after or in 2021. It means like the gap of 6 months to 1 year gap, wherein both the parties have started genuinely, honestly, bona fidely the same or identical name with the good intention. There was no intention to take advantage of the other's name. So the section 12 will, the examiner might allow the subsequent trademark which is identical to other one. The section 13, which talks about the chemical compound. We see that a lot of time in specifically in pharmaceutical industry. And if we say in context of the Trademark Act, then the classifications, the class 5 is specifically used for pharma or the medical or the healthcare industries. So when you file a trademark application under class 5, there are more chances that people start using the name of either the disease name or the chemical compound name or new chemical entities name, or which is very commonly or widely used in that industry. From a doctor could use, or a patient could use, or the manufacturer could use, or a trader could use, or the retailer could use, which is very famous in that industry. People will always try to have that name. So the registry has specifically mentioned that any chemical compound which is already invented, or means like which has been known, which is known and commonly used in the study, or which is spoken commonly, generically in the market, will not be allowed any trademark application on that name if they claim that chemical compound. Section 14 that talks about the name of any live or dead person. For an example or instance, if you use any celebrity's name or freedom fighter's name, or which is very famous among public and in the public domain, and you think that by using that name you can take the leverage of or to sell your product, so uh, you have to take the written permission from that person for or whose name you have used, or even it could be a common person also. Suppose me and you and yours name also, if it is commonly yours name also is being used by third party, and you think that that is my name and they are using my name, so you can claim it or you can object it, or registrar will consider that either you have the written permission from whose name you have used it, or the either his name if the person is dead. So the section 14 talks about that. Section 15, 16, and 17 are mainly about the series of the mark, association of the mark, and the effect of the part of the mark. Mainly, if you file a trademark application which has a lot of combination of the trademark or the lot of combination of the description of the goods, like it could be a name, it could be a title, it could be a punchline, it could be an image, it could be any other artistic design, then registrar may ask you to have the separate registration for if you are claiming that part of the trademark separately. Suppose the Apple uses its Apple logo at as like for on a stationery or their electronic product or on advertisement, so they need to file a separate application for it, and Apple word itself should be filed separately, or if they are using punchline or the tagline, they have to file the separate application. So the limitation of the 15, 16, and 17 is that each part of the mark should be protected separately. That talks specifically under section 17, but 15 is a series of the mark, like if you are using cello pen, there are a lot of series of the mark like cello thick, cello fine, cello cushion, cello long, cello scratch free. So there are a lot of series of the mark. Like specifically you see in Patanjali, they use the mean under the umbrella of Patanjali, Patanjali Ojas, Patanjali this, Patanjali that. So that's a series of the mark, which is known that the main trademark is Patanjali, and there are a lot of series of the mark. The final objection which trademark registry could raise is under section 11, wherein trademark registrar has an inherent power in himself under section 18.4, wherein he could accept or reject any trademark. So I believe that the objection of the trademark is a part of the prosecution process, wherein the trademark registrar or examiner will raise an objection on the registration of the application that you cannot have the registration of these names under section 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. 9 to 18 all are the objectionable sections. Now, so if the objection is raised under the examination report, which is issued by the trademark registry to you, you have to prepare a reply to that examination report to defend your application and to prove that your trademark is not violating any of the section, which is coming under section 9 to 11, 10, 18. There are a lot of incidences wherein trademark registrar himself could give you a disclaimer by saying that at a time of accepting your reply, that your application will be limited only to these descriptions or these names or these logos or these words or these digits. At the time of submission of the trade application, you can also applicant and all the wherein you they mention that we do not want to this name. It is very important for brand to use it since using it, but they know that it's a generic and can be used by others, or they find it, applicant find it that it be on record or already else. The registrar can also object your limitation. So the second part of that, wherein we today's topic of comparison between the objection and the opposition. So I'll start the second topic of the opposition. So the opposition is again is a part of the prosecution process, but only difference between objection and opposition is objection is always raised by the trademark examiner or the registrar, while opposition is always raised by third party. Third party means you are the applicant, you go to the trademark registry and you ask them to award your name or right of a name, that's a trademark. While when you procure your right, there's a third party who has an opposition or by saying that this application should not be granted because I have these objections. That term objection means they have the term opposition has an objection, means like the they want to oppose this application not to get registered, because it could be a lot of reasons. They are already registered, they are there in the market, they do not want you to get it registered, or a lot of other options which I'll explain in detail. Under section 21 of the Trademark Act 1999, the opposition is defined, when the process of the opposition is similar to, if you are aware about of, or if you have happened any instance of buying any property and you go and then you publicize that one property you have purchased in the market and you publicize in the newspaper. Similar to that, this is an intellectual property. The form of the intellectual property is the trademark. So when you procure it, the registry will publicize your brand name once the objections, which I have just explained before this topic, that the objection is raised by the trademark examiner and you fulfill by submission of your examination report, examination reply. Once the examination reply is accepted, your application will be accepted and advertised. So the advertisement of your application will be done in the trademark journal. Every 15 days, the trademark registry will publish your journal, wherein all the jurisdictional trademark will be publicized. That and will be given detail about that with the limitations or with the disclaimers or with the user date, with the goods description, the applicant name, the logo name, all the description will be given under the trademark journal, and that is accessible by everyone. That is in publicly available online in the IP India's website. You can access it. You can see that a lot of people give the watchdog services wherein that they will find that similar name is there or not. So when you come across a similar name or identical name to your brand name in the trademark journal, so you try to stop them, because the other name might create a competition in the market and you will not sustain your monopoly as you used to maintain in the market. So you try to stop them. The process of stopping them is called opposition. Or a third party who's thinking that if you are the applicant and you have filed the trademark application, the third party is opposing you. They are intent to stop you to procure that name or the brand name or the trademark registration in your favor. So the process of stopping is called opposition. The term is used under section 21 of the Trademark Act is called opposition. So opposition has its own process, and it is defined under the subsection of the section 21. So when a person is intent to oppose an application, they have to prepare their notice of opposition. Notice of opposition means you are sending a notice to the trademark registrar by saying that I have these contentions, the statement, submissions, averment, allegations on these names. So you give your submission to the trademark registrar, and the registrar will forward that copy to the applicant. And that should be done within 4 months of the publication date. When your name is published in the trademark journal, you have to take or consider that date from that date of publication to 4 months or 160 days. Within 160 days, you need to oppose it. A lot of time it happens, and in practical aspect, we see that in practice that सर मेरा तो ट्रेडमार्क निकल गया है, या फिर हम तो ट्रेडमार्क अपोज कर नहीं पाए हैं क्योंकि उसका 160 days या 4 months पूरे हो गए. So a lot of time this happens wherein you are not, you were not aware about it, or you were, have not checked online that any similar or identical name is published or accepted by the trademark registry or not. So sometimes you cannot oppose it. So there is another process for that, rectification. That's not the part of the topic, but yes, in the registration process, you can oppose them within the 160 days of time. Once the notice of opposition is sent to the applicant by the opponent, then the applicant has to reply that notice of opposition with the counter statement. Now, what you can write in the notice of opposition? There are a lot of things, as I explained before in the objection, which Section 9 is the main thing. You can say that these names are generic and these names are showing kind quality values, or Section 9 total were not applied on it, and that is just surpassed their Section 9 and they got the application accepted or the published. So I want to oppose it on that ground. It could be Section 11 also, that as I explained you that my name or the other's name were already available on record. So the subsequent applicant should not be allowed to have this registration for the identical name or with the same name, or my brand name is very well known and they should not have the registration in other class also. So apart from that, there's a term called likelihood of confusion or likelihood of association. The main preamble of the trademark is that people should not get confused that the product is related or belonging to the same owner. It could be a different quality of goods. It could be a different uh, process of the goods, or it could be a different quality of the services. But if the name is there, which is identical, similar, people might get confused. So there is a likelihood of association with the already existing trademark in the market. The subsequent trademark could take a leverage or the advantage of that famous or already existing trademark in the market. So you can have the defense of that also, that there's a confusion is happening and likelihood of association, the confusion is there. And you can also give the defense of the other sections, like the limitation of the colors, which I have shown under section 10, the section prior user, that you are the prior user to them and you have been using it. You can also say that you have not filed a trademark application, or you have filed, you can give the reference to that trademark application, or the multiple trademark application, you can give the reference to that also. The similarity in the goods or the identity in the goods, you can also show that my goods is related to under the same class or different class, but the description is same or similar. Now, what's the difference between similarity or identity of the same goods? Identical goods are like, if you are making chocolates, the other person is also making chocolates. It's identical goods are there. But if you are making chocolates, other person is making flour. So both are coming in the same class, but the description of goods is different. So a lot of time, a lot of incidences wherein the goods are coming in the same class, but the description of goods is different. A lot of time, the goods are coming under different classes, but are also description of goods are considered similar. Like for an example, section 29 and 31 for mouth freshener. A lot of time there's a confusion that mouth freshener will come under class 31 because they're related to the pan masala, and but actually it is coming under class 29. So the confusion is still there. So registrar will always consider that what is generally perception of the consumer in the market, and they would not, or they might not allow your name to get registered. So the oppositions, the next step is when you send a notice of opposition with your statements or allegations to the application, then applicant will prepare the counter statement to that application by saying that you have been using this name, you have adopted this name by so and so reasons, where my son's name was my father's name or any other's name you have adopted, or goddess name or anything. Generally in India, a lot of people use the name of which are very commonly used or related to the astrologically defined name and all. So you give your own defense to justify that why you have chosen this name. Sometime you say that you have coined a name, but actually those names are already available or already on there. You try to defend it. If you are genuinely, you have taken that or you have coined that name, then you will be able to prove it, that from where you have taken this, how have you designed this, when did you think about this, and how you framed it, how you design, like how you made the logo, or you have asked to prepare it, the combination of colors, fonts, and a lot of things you will justify. And so it will not show that directly you have picked up the name and you have started using it. And so that will show that you are trying to take the advantage of the other's goodwill, which is there in the market. So you will try to prove it that the name was actually coined or invented by you. And you want to use this name because you own this name and you have sentiment attached to that name. Then the other difference, like similarity of the name, you can also say that my business is related to the specific geographical location, which is a certain kind of people or targeted audience, or the customers are only related to it, and they are well aware about it. You can also give a difference that if since we have been using and we have recently filed the trademark application, why have you not sent us the legal notice to stop? If you say that you are the prior user, and since we are well known in the market, why have you not sent us so far any kind of legal notice or to stop us, any email or any intimation to us, which wherein you can mention that your trademark application is similar to us. So you can also give the defense into it. Apart from that, the section 11, section 12, honest and concurrent uses, you can show that I have adopted the name honestly, and I have recently started. You have also recently started. So this is a concurrent uses, and we both should be allowed by the trademark registrar. So this process of the opposition is filing notice of opposition, replying to the notice of opposition by way of counter statement. Then there is a process of submission of the evidences. So from the date of publication to 4 months, notice of opposition. Within 2 months from the notice of opposition to submission of the counter statement. Within 2 months from the counter statement, applicant means opponent. Opponent will submit evidences in support of notice of opposition. Means whatever the oppositions or the allegations I have made, I have to justify with the supporting evidences. Why am I saying this, or why am I opposing this thing? So evidences could be your sales bill, your purchase bills, your advertisement materials, your turnover, your it could be your document or R&D documents. It could be your website copy. It could be your on a lot of platforms availability. Like if you are on India Mart, or if you are on Just Dial or Yellow Pages, or a lot of places you were available. So you can prove your prior usability that you have been using since that. So those evidence will be considered as a very substantial evidence at the time of submission of the evidence in support of notice of opposition. Then applicant will get, applicant turn will give them, allow them to submit their evidences. So they would submit those evidences which are in support of the counter statement. Whatever you have given your defenses, you will give the evidences related to the counter statement. It could be that how you have derived your name, how have you conceptualized your name, then your sales bill, purchase bill, your turnover, how much you are famous in the market, how many customers are aware about you, how many testimonials you have not taken, you have only generated. In short, you have to prove your honesty that the name were taken, whatever the name you have filed is genuinely taken, and you are doing genuinely business. You do not want to take any advantage of the already available trademark, or it is not generic. So mainly, most of the oppositions are generally filed by the prior trademark applicant or the registered owner, wherein they think that the subsequent applicant might create the competition in the market. Generally, the maximum oppositions which I have seen in my practice is filed by the pharmaceutical companies. They do not want to let other competition come in the market and grab, or they want to sustain their monopoly in the market. So they refrain you by filing the opposition. That's a part of the prosecution process. Now, at the last stage of the opposition is the filing of the another evidences. That's one more chance, which is given to the opponent to submit the additional evidences. So the notice of opposition, counter statement, evidences in support of notice of opposition under section or under rule 45. Then applicant will get a right of submission of the evidences in support of the counter statement under rule 46. And one more chance, submission of the additional evidences in support of the notice of opposition under rule 47. Here, the whole process of the opposition of submission gets end, and after that a date will be assigned for the hearing to justify both the matter to both the parties, that who is the genuine or not. If the opposition is found to be like ingenuine, or like they have filed the trademark the oppositions by just sake of refraining, or which is not at all similar or identical to their brand name, neither to their goods or services, then the opposition will be refused and the application will be accepted to grant. While if the opponent could prove that they are the genuine applicant or the prior user, or by evidences they could prove it, then application will be refused. So here the opposition process is to stop or to take the action to stop the trademark application by the third party, while the objection is filed or the raised by the trademark registrar or the examiner. Both are the part of the prosecution process of the trademark application. When you file a trademark application, one objection is raised by the trademark registrar or examiner, and once your application is accepted by the trademark registrar or the examiner, there is a process of the opposition which is raised by the third party to stop your application to get registered. And once the whole prosecution process is completed, you're awarded by the trademark registration certificate. So this is a main comparison which I've shown you. And there are other things also, which all those things I have explained you, difference between the objection and the opposition, both.
Hello, sir.
Yeah.
Yeah, thank you so much for the wonderful session first. And my question is, what kind of evidence do we need to present in opposition to the trademark?
Okay. Okay. So there are a lot of evidences which you can prove. Because basically, the nature of opposition is when you are intending to stop the other party to get the registration granted in their favor, right?
Okay.
So you have to prove that you are the genuine. What is the logic of stopping them? It could be like they are coming in your way, like in your competition. So, or either you have filed the trademark application or not, that doesn't matter. But if you want to stop, then you have to prove it that application will hamper your business in the market, or not business, your trademark application or your brand name in the market. So you either you can submit the sales bill or the purchase bill, which are related to that particular name. You can submit any advertisement document. You can submit the logo designer's receipt, wherein the logo designer has given you that I have designed this logo for you and I have charged this much. You can design any listing on like social medias, on LinkedIn, on Instagram, on Facebook, wherein you could show the date. You can show the advertisement in newspaper. You can show the advertisement in leaflets and your brochures, your packing material, but packing material will not have the date specifically. So any document which could prove your GST number, if your trademark is related to your trade name, also trade name means your company name. Like Hindustan Lever is the trade name, while Head and Shoulder, Love, and Lux and Dove all are the brand name. Fine. The trademarks are Lux, Dove, and Head and Shoulder, while the trade name is Hindustan Unilever. Sometimes they also go for trademark registration of the company's name. So if your company's name and your brand name both are same, you can show the shop and establishment certificate as a government document. You can show the GST certificate. You can show your PAN card You can show your if it is related to the pharmaceutical product or cosmetic product, the FDA license, the cosmetic license, or food license. Anything related to the any government law document will can suffice. Like would be considered as a very good evidence. Anything which could prove that you are the prior user or you are using that brand name, that's why you wanted to stop them. Or if those names are generic, you have to prove it by submission of those documents. Like if someone has filed the name turmeric, so our Vedas, Puranas, the old script and all, you can submit to justify that these names are generic name and they cannot take this name. So this is the discretionary power of the registrar. They might or might not get the registration done. Got it? So any evidences which is related to your brand name should be there in your evidence. Like if you are submitting the bills, your name or brand name should be there with the date. They would accept. That would be considered very strong evidence. Okay?
Yeah. Thank you so much, sir.
Yeah.
So the next query is, what do we need to register under a trademark, partnership logo or word mark?
पार्टनरशिप नहीं होगा. आप मुझे लगता है आप डिवाइस मार्क और वर्ड मार्क में कंपैरिजन कर रहे हैं. पार्टनरशिप लोगो
Yes, maybe sir. Yes.
हाँ, डिवाइस मार्क और वर्ड मार्क पूछ रही है.
Trademark, partnership logo or word mark. These are the three
क्वेश्चन है. मैं उसको कर देता हूँ. पार्टनरशिप के अंदर फाइल किया है या प्रोप्राइटरशिप में फाइल किया, या तो ये क्वेश्चन होगा या फिर ये होगा कि वो डिवाइस मार्क है या वर्ड मार्क है, कौन सा फाइल करना चाहिए.
Yes sir, I think.
ठीक है, मैं दोनों के रिप्लाई दे देता हूँ ताकि दोनों में ही क्वेश्चन गलत भी होगा तो भी ठीक है. डिवाइस मार्क वो होता है जिसके अंदर में कोई इमेज दे रखी है. जैसे मान लीजिए कोई ग्लास का फोटो है या शेर का फोटो है या उसके नीचे कुछ वर्ड लिखा है, एप्पल का फोटो है उसके नीचे कुछ किया, तो वो डिवाइस मार्क कहलाता है. जैसे कोका कोला है वो स्पेसिफिक फॉन्ट में लिखा हुआ है तो भी वो डिवाइस मार्क कहलाता है क्योंकि वो स्पेसिफिक स्टाइल में लिखा है. वर्ड मार्क टाइम्स न्यू रोमन में सिंपल लिखा हुआ कोई भी वर्ड, यानी कि APPLE सिंगल टाइम्स न्यू रोमन में लिखा है तो वो वर्ड मार्क होता है. आजकल का ट्रेंड है कि Amazon नॉर्मली वर्ड मार्क फाइल किया हुआ होता है तो वो ज्यादा लेता है, क्योंकि हमारी पब्लिसाइजिंग और कैंपेनिंग कैंपेन्स चेंज होते रहते हैं, हमको अलग कॉम्बिनेशन के साथ में ब्रोशर्स के अंदर अलग यूज करना होता है, यानी कि ब्रांड आइडेंटिटी चेंज होती रहती है। तो नॉर्मली एडवाइजेबल है कि वो वर्ड मार्क में जाएं, जिससे आप अलग, लेकिन किसी को लगता है कि नहीं मुझे तो यही हमेशा फॉन्ट रखना है, यही कलर रखना है, यही लोगो रखना है, तो आपको वर्ड डिवाइस मार्क में जाना चाहिए, यानी कि लोगो मार्क जो उसका आर्टवर्क है टोटल उसमें जाना चाहिए। जैसे मैंने आपको एग्जांपल दिया था कि मैगी का है, वो येलो कॉम्बिनेशन जो है वो हमेशा वैसा ही रहना है, उसका डिग्री भी वैसा ही रहना है, तो वो उसको उस पैकेजिंग के टोटल पैक के साथ जाना चाहिए, ताकि वो कोई भी उसमें अंदर में चेंजेस नहीं कर सके। डिपेंड करता है कि आपको किस प्लेटफॉर्म पे कैसे लॉन्च करना है, प्रोडक्ट कौन सा है, आप क्या स्ट्रैटेजी है आपकी, उसके हिसाब से आपको एडवाइस दी जाती है। वर्ड मार्क में जाओ, लोगो मार्क में जाओ, या सेपरेट सीरीज ऑफ द मार्क में जाओ। अच्छा, दूसरा एग्जांपल है कि प्रोप्राइटरशिप में फाइल करना है या पार्टनरशिप में फाइल करना या प्राइवेट लिमिटेड में फाइल करना चाहिए ट्रेड। प्रोप्राइटर में ट्रेडमार्क फाइल करते हैं तो आप इंडिविजुअल नाम के साथ फाइल करते हैं। पार्टनरशिप में नॉर्मली लोग फाइल करते हैं तो वो प्रॉपर्टी है जो पार्टनरशिप की हो जाती है। जब पार्टनर अलग होते हैं तो बहुत डिस्प्यूट आते हैं कि ये नाम मैं रखूंगा या इसकी कुछ वैल्यू आप मुझे दे दो, और फिर दोनों एक दूसरे के सामने करते हैं, कंपटीशन होते हैं और वहाँ बहुत प्रॉब्लम्स होती है। कई लोग ऐसा भी करते हैं, पार्टनरशिप कर लेते हैं लेकिन ट्रेडमार्क अपने, जिसको नहीं पता होता है वो अपने पर्सनल नाम से एक जो ज्यादा एक्टिव होता है वो पार्टनर अपने नाम पे करा लेता है, फिर बाद में पता लगता है कि दूसरे पार्टनर को कि वो तो ट्रेडमार्क पार्टनरशिप में है ही नहीं, तो वहाँ बहुत सारे डिस्प्यूट्स होते हैं। तो ये कंफर्म करना जरूरी है कि अगर पार्टनरशिप में नाम डाला है तो पार्टनर्स का नाम, दोनों का नाम या फिर पार्टनरशिप डीड उसमें सबमिट होनी चाहिए, जिसके अंदर दोनों पार्टनर या तीनों पार्टनर या जितने भी पार्टनर्स हैं उनके नाम आए। कई बार ऐसा भी इश्यूज आते हैं कि एक पार्टनर छोड़ के गया, उसका नाम तो ऑनलाइन शो हो रहा है, जो नया ज्वाइन हुआ उसका नहीं दिख रहा है, तो उसमें आपको चेंजेस करा सकते हो, उसका प्रोसेस है ट्रेडमार्क रजिस्ट्री में। और प्राइवेट लिमिटेड है, वो भी एक लीगल एंटिटी है, आप फाइल करोगे तो प्राइवेट लिमिटेड के अंदर में सिर्फ फीस का फर्क है थोड़ा, 5000 एडिशनल लगती है प्राइवेट लिमिटेड में, बाकी प्रोप्राइटर और पार्टनरशिप अगर उन्होंने एमएसएमई का सर्टिफिकेट दिया है तो 5000 में पूरा हो जाता है, नहीं तो 10,000 है गवर्नमेंट में। ये एक फर्क है। तो मैंने आपको बता दिया लीगल एंटिटी किस नाम से फाइल करनी चाहिए, ये भी बता दिया कि कौन सा ट्रेडमार्क का वर्ड मार्क है या डिवाइस मार्क है, कौन सा फाइल करना चाहिए।
Sir, the next question is whether opposition can be filed after expiry of 160 days by way of condonation of delay, application, etc.
हाँ, देखिए बहुत अच्छा क्वेश्चन पूछा है आपने। अभी जो रिसेंटली कोरोना के अंदर हुआ था उसमें स्पेसिफिकली नोटिफिकेशन निकाला है, लेकिन उसके अलावा बहुत मुश्किल है। हालांकि उसके लिए आपके पास में एक प्रोसेस है, आप इंटरलॉक्यूटरी पिटीशन फाइल कर सकते हैं कि कोई रीजन, मेरा एक्सीडेंट हो गया था या मैं इंडिया में नहीं था, तो बहुत सारे रीजंस हैं कि आप इंटरलॉक्यूटरी पिटीशन फाइल करके उसकी अपील आईपीएबी में कर सकते हो या उसमें रजिस्ट्रार को दे सकते हो, लेकिन बहुत रेयर होता है कि वो एक्सेप्ट होती है। आपको 160 डेज का टाइम इसीलिए दिया गया था कि आप उसको पूरा चलने दें, नहीं तो आप लोग क्या करेंगे, उसको बढ़ाते रहेंगे, टाइम हर बार एक्सटेंशन ऑफ द टाइम लेते रहेंगे।
Okay, sir. Sir, the next query is what is the difference between cease, desist and opposition?
सीज डेसिस्ट एंड ऑपोजिशन,
Yes.
बहुत अच्छा क्वेश्चन है। सीज एंड डेसिस्ट जब अपन नॉर्मली नोटिस भेजते हैं, जब हम किसी को, ऑपोजिशन वो होता है जो प्रोसिक्यूशन का पार्ट है। जब रजिस्ट्री में आपने एप्लीकेशन दी है और एप्लीकेशन को ग्रांट नहीं होने देना है तो वो प्रोसेस को ऑपोजिशन कहलाता है, जबकि सीज एंड डेसिस्ट आप किसी को वो नाम यूज करने के लिए बंद करवाना चाहते हैं, जो प्रोसिक्यूशन यानी कि ट्रेडमार्क रजिस्ट्रेशन का पार्ट नहीं, यानी कि एडवोकेट सीज एंड डेसिस्ट नोटिस भेजेगा, सामने वाली पार्टी को जो कॉपी कर रही है उसको ये बोलेगा कि जो ट्रेडमार्क फाइल कर रहा है या नहीं कर रहा है इससे कोई मैटर नहीं करता, लेकिन ये नाम हमारा है, तुम यूज मत करना, नहीं तो हम आप पे सूट फाइल कर देंगे। यानी कि आप हमारा नाम इन्फ्रिंज कर रहे हो या पास ऑफ कर रहे हो। पासिंग ऑफ का मतलब है जब आपका नाम रजिस्टर्ड नहीं है फिर भी वो यूज कर रहा है, और इन्फ्रिंज जब आता है जब आपका नाम रजिस्टर्ड है और वो यूज कर रहा है, यानी कि कॉपी कर रहा है विदाउट आपकी परमिशन। तो सीज एंड डेसिस्ट हो गया जब लीगली नोटिस भेजना होता है और बंद कराना होता है। ऑपोजिशन वो हो गया जब रजिस्ट्री के अंदर में ट्रेडमार्क रजिस्ट्रेशन को रजिस्ट्रेशन नहीं मिले इसके लिए रोकना होता है, तो ऑपोजिशन होती है। क्लियर हुआ?
Yes, sir. Yes.
थैंक यू
Thank
फॉर
you.
इनवाइटिंग मी।